Hearing in the Queen on the application of Steinfeld and another against Secretary of State for International Development.
My ladies.
Well, Ms Monaghan, we thought we ought to point out to you that the issues have so narrowed that, of course, all we've got is justification and whether, if it's not justified, we should make a declaration of incompatibility. So, strictly speaking, Mr Eady should be on his feet and not you. Don't sit down.
Tempting though it may be.
So, in the light of that, it struck us that we could invite you to make your submissions as briefly as you feel able to do. We do not, any of us, think that we're going to need a day and a half in this case.
My lady, thank you. Well, I shall deal with them as briefly as I can, and I might have to skim through some bits then as I go along because I've prepared a speaking note, but I will do my best to deal with it coherently.
Well, we knew you would, which is why we put it to you.
Just a couple of preliminary matters, if I may. I think you will have observed already from the calling out of the case, bringing on of the case, that the identity of the respondent has changed yet again. We're now Secretary of State for International Development. That's the fourth so far. There is also an application that I think hasn't yet been determined to adduce evidence in by way of a witness statement that's in the core volume, a new witness statement from the respondent. I don't think that application has been determined. We're completely neutral on it, and indeed it makes sense, given what the issues are in this case, for the court to see it.
Yes.
And we will say in due course that it doesn't help the respondents at all. There was also on Thursday a command paper published. That ought to be on your bench, and that identifies what the respondents now say they're proposing to do by way of progressing their plan. I'll come to that very shortly, and I can deal with it very shortly in due course. You ought to have two, an updated table identifying the current position in relation to Council of Europe member states. And that really was just updated to take account of some developments in Austria and Malta. Doesn't deal with the Isle of Man, but you'll know, I know, my lady, that the Isle of Man does, of course, have civil partnerships open to both same-sex and opposite-sex couples. But the short point that we extract from the table is simply that there are no member states of the Council of Europe that have introduced same-sex marriage while retaining civil partnerships for same-sex couples only. In other words, they haven't conferred a greater choice on same-sex couples. So they've either got rid of them or they've equalised them. So you'll know what the issue in the case. I won't trouble you with all of that. I just would like to say, my lady and my ladies and my lords, something about the appellants and the nature of their objections, in particular because below they were not taken to weigh very heavily in the balance. Perhaps don't need to take you to that in view of your observations, but I do want to say something about their particular situation and others in a similar situation. First of all, as you know, indeed it's the issue in the case, they're an opposite-sex couple. They explain their beliefs in their witness statement, in particular the witness statement of Ms. Steinfeld. I don't need to take you to that, but in short, they have deep-rooted and genuine ideological objections to marriage.
Well, that's been accepted, hasn't it?
It has, but I simply want to observe that they are not alone in holding those deep-rooted objections, and nor are they unimportant, irrational, or frivolous. The reality is that marriage historically has been both heteronormative and patriarchal. Women were made invisible in it, although many, indeed most, of the patriarchal trappings of marriage have now gone, including its heteronormativity. The social habits that remain, and symbolism is important, which is why same-sex marriage was important, many of the social habits remain, the giving away of the daughter from the father to the husband, the custom of a woman taking the husband's name, and even still some of the formal aspects relating to marriage reflect its patriarchal history. So the prescribed particulars for registration of a marriage include details of the father of the bride, but not the mother.
I thought they were going to change that.
They have been promising to change that for some time, but the provisions were most recently enacted in 2015 when fresh regulations dealing with particulars were introduced. So as recent as 2015, provision is made for registration of the father but not the mother. And of course there are still rules on consummation. Neither of those apply to civil partnerships. Consummation, so a marriage is voidable, as I know your ladyships and your lordship will know better than me. A marriage is voidable if it's not consummated. That's especially important in circumstances where until 1991, a husband could compel the marriage to be consummated without consent of the wife and with impunity so far as the criminal law is concerned, because, of course, a woman was taken to have provided irrevocable consent to having sex with her husband upon marriage. So important issues, no small matters, and they are serious for my clients because they cannot marry conformable with their conscience, and that should weigh very heavily indeed. As to the background to same-sex marriage, you will have seen there was a consultation exercise. There was a response to that consultation exercise, and I do want to just pick up one or 2 points, if I may. If I can ask your ladyships and your lordships, please, to turn up the core volume and go to Appendix Part 1, page 128, MS 291. This is the start of the consultation exercise. This predates, of course, the introduction of the Same-Sex Marriage Act, as I'll call it for ease. MS 296, that's page 133 of the Appendix Part 1. You'll see at paragraph 1.1 that this consultation exercise, this is the response to the consultation exercise I'm looking at now, this consultation exercise resulted in the largest number of responses ever received to a government consultation. We see that at paragraph 1.1. 228,000 people responded. And if we look at the response in relation to opposite-sex civil partnerships, if I can ask, please, your ladyships and your lordships to turn up page 161, internal numbering, MS 330 of the MS number, page 167, MS 330. We see under questions 3 to 13 inclusive, 137,000 respondents answered at least one of the other specific questions. 137,000 answered at least one. And we see over the page the answers to the particular questions that are relevant here. Question 6. Do you agree or disagree with keeping the option of civil partnerships once civil marriage is made available? And the answer, yes, 66%, and that's 84,994 individuals. And then question 8, the government is not considering opening up civil partnerships to opposite-sex couples. Do you agree? 61% disagree. That's 78,556 people. So there is a strong objection or disagreement with the government's stated position at that time that civil partnerships should not be open to opposite-sex couples. Just looking, please, if I may, briefly at the Act then, the Same-Sex Marriage Act, Volume 1, Tab 3, MS 850. You'll see that page 852, MS 852, which is page 3 of the printout, marriage became lawful. Perhaps worth just drawing your ladyship's and your lordship's attention to the fact that the Act was enacted in 2013, so nearly 5 years ago. It came into force, we look in the annotations under section 1, 13th of March 2014. So your ladyships and your lordships may recall that the first same-sex marriage occurred towards the end of March 2014, some very long time ago. Provision was also made under section 9 for conversions, but more particularly perhaps for these purposes, section 15, MS 856, provision was made for a review of civil partnership. So Secretary of State must arrange for the operation and future of the CPA to be reviewed and for a report on the outcome to be produced and published. There was thereafter another consultation exercise, no doubt pursuant to that, and we see that in the appendix part 1 at page 175. And that was in June 2014.
Is that the electronic?
No, it's MS 338.
338, thank you.
I beg your pardon, did I?
Didn't give us it.
Sorry?
Cardinal sin.
What did I do? Not MS it, I beg your pardon. I plead rushing through my notes more quickly.
Yes, it's
than I
our fault.
anticipated.
So this was a civil partnership
This
review.
was the civil partnership consultation, and it sets out at page 182, MS 345, what happened during the course of the parliamentary debates on same-sex marriage. Concerns were raised about the continuing role of civil partnerships, and Parliament agreed to insert what became section 15. And 1.4, government's decision not to make changes to civil partnerships was because civil partnerships plainly plays an important role in the lives of many couples, and so on. And then there was a response or a summary of the responses to that consultation exercise at 221 MS 384. And I can perhaps just deal with this very quickly given where we are. Page 223 at 386, so moving to the executive summary, appendix 223, MS 386. A relatively small number of respondees, over 2,000, somewhere over 11,000 in fact. And in the bullet point summary, less than a third of respondents supported the abolition of civil partnerships. Majority were against closing them to new couples, and over 3/4 were against opening up civil partnerships to opposite-sex couples. So keeping them open, but only for same-sex couples, but a relatively small number of respondees, and we see the particular number at page 225, appendix number, MS 388, 11,500 responses. And the government's decision not to make any changes at that point, at least. These proceedings were then issued in December 2014, for your note. The principal ground relied upon by the respondent in response to the claimant's, the appellant's claim of discrimination, that discrimination they contended arising from the introduction, the enactment of the Same-Sex Marriage Act, which conferred a choice upon same-sex couples that they did not enjoy, that is between same-sex marriage and civil partnerships, that being the discrimination, the respondents relied principally, as you will have seen, on the contention that the complaint, the factual circumstances didn't fall within the scope of Article 8 at all. Ultimately, they were unsuccessful on that point in the Court of Appeal, and they haven't persisted with that argument. But as to the evidence relied upon in support of justification, firstly, the articulation of the justification relied upon, although it's varied from time to time in terms of its precise terms, the respondent's essential claim is that in the absence of consensus, they are entitled to take some time to ensure that the measures introduced to remedy the particular situation now are the right ones. So in other words, to decide, consult, evaluate, and determine what steps they ought to take. What they do not say, and have not said, is the continuance of the distinction in treatment has some objective justification as such. Their justification is premised entirely on the need to take remedial action, recognising something needs to be done, and the need, they say, to take time to ensure that that remedial action is the right action. Just if I can just take you briefly to the evidence. Appendix Part 1, page 96, internal numbering, MS 259. This is the statement of Ms. Hobman, relied upon by the respondents, explaining the position at that stage. And in particular, you will observe from paragraphs 4 onwards, I needn't read them out to you, but you'll observe that the focus at that stage was on identifying the uptake of civil partnerships among same-sex partners. Of course, civil partnerships weren't and aren't available to opposite-sex partners. The focus there was on the continuing interest among same-sex partners, no indication that any research or inquiry was going to be made about the interest that might exist among opposite-sex partners in entering into civil partnerships as opposed to marriage. As to that was the evidence before the first instance court. And if I can just please turn up what the Court of Appeal said about it, I think I can, without discourtesy and with the greatest of respect, not trouble you with the first instance decision, because much of that was in relation to the ambit question. So I don't mean that discourteously to
I'm sure Mrs. Justice Andrews will understand.
I beg your pardon?
I'm sure Mrs. Justice Andrews will understand.
If she's watching, you never know. So if I can please just ask your ladyships and your lordships to turn up the Court of Appeal judgment. Appendix Part 1, internal numbering page 5, page 168. As your ladyships and your lordships will have picked up, the court was unanimous in holding that the complaint fell within the ambit of Article 8. There was a split, however, in relation to the issue of justification, with Lady Justice Arden concluding that the continuance of the distinction as between same-sex couples and opposite-sex couples was not justified. And if I can ask you please to turn up page 32 MS 195. There was an issue, and there remains an issue, about whether or not the aim articulated by the respondent, let's wait and see and get it right, could ever be a legitimate aim for the purposes of justifying discrimination. Lady Justice Arden dealt with that from paragraph 104 onwards, page 32, MS 195, and concluded at paragraph 105 that the justification, the aim articulated was capable of constituting a legitimate aim, the aim of avoiding unnecessary disruption and wasting money, as she described it, paragraph 104, lifting the section from the judgment of Mrs. Justice Andrews dealing with that. So it does, she says, constitute a legitimate aim in the particular case. We say no. But paragraphs 110 onwards, 110 onwards, page 33, MS 196, it was not proportionate, didn't strike a fair balance, and identifying, and I only need to give you the headline points, identifying in particular at 1, policy of the Secretary of State is open-ended. It still is, and indeed, if anything, it's become even more open-ended, as I shall take you to. It's only directed to obtaining information about same-sex couples, as was the position at the time. Doesn't address all the important issues, that is the freedom of choice, for example, for opposite-sex couples. Not responsive to the statistics. And there's no realistic...
Did you get some statistics wrong, Ms. Monaghan? Perhaps your junior could look into that. In paragraph 120, there's a reference to 891 in the final line of 120, and I was worried that that might be wrong. Could you come back on that?
Thank you.
Thank you.
I'll certainly do that. And the absence of any assessment of impact in relation to resources and cost. The majority, however, concluded that it was... my Lord, we have found the reference for your Lordships, or Ms Hannett's kindly done it. It's page 258 of the...
Is it wrong or right?
It's right.
It's right.
Oh, it's wrong. Oh, I beg your pardon. I'm sorry, my Lord. You're right, and I'm...
Very well.
It's 861.
I wondered whether it was.
I'm sorry. Thank you, my Lord.
I think that means that her percentage that she's calculated is slightly wrong too. Let's not bother with it, Ms Monaghan.
But thank you for drawing that to our
Not
attention,
at all.
my Lord.
Not at all.
So the majority, however, concluded that not only did the aim sought to be realised by the delay, as I shall describe it, but it was also proportionate. And if I may just take you to some of the observations in relation to that. Firstly, Lord Justice Beatson, at pages 47 to 48, MS 210 to 211, looking at paragraph 158, if I may first, concluding that the position is objectively justified. Future of the legal status of civil partnerships is an important matter. Secretary of State's approach was described as wait and see, although more accurately, wait and evaluate. Whatever terms used to describe the approach, it would not have been available prior to the enactment because it wouldn't have been possible to make an assessment of the take-up of civil partnerships.
Of course, this isn't a question for you, really, Ms Monaghan, but I have some difficulty in understanding how the attitudes of same-sex couples, who on any view are not going to be imbued with the same problems of patriarchy and heteronormativity as are opposite-sex couples, how those changes in attitudes could be relevant to opposite-sex couples whose objections, as you have pointed out, are based on the historic perception and social habits that come from that historic perception. How could that be relevant to, how could same-sex couples' attitudes be in the slightest bit
Well, I think
infected by those problems?
that was precisely the point that I think Lady Justice Ardent was making. How does it help determine whether or not opposite-sex partners would wish to access civil partnerships? And of course, that was we say, the inadequacy in the witness statement of Ms. Hobman, who says nothing except we're waiting to see whether same-sex partners will continue to take up civil partnerships, which doesn't go at all to the question of discrimination or distinctions in treatment, if I put it more neutrally. And that persisted until this year, as I'll come to in due course. I perhaps should just say one thing, because I will get emails otherwise when I go back to my chambers. There are lesbian and gay couples who don't enter marriage for precisely the same reasons. They don't want to be assimilated into an institution that they regard as patriarchal and carrying with it historical inequalities that they regard as objectionable to new forms of relationships. I only say that because I will get many emails. But yes.
Well, that is completely understandable, but nevertheless, it's a different set of attitudes and a different set of objections.
Yes. But precisely, my lady, there was no consideration at that stage, and had been no consideration even by the Court of Appeal stage, about any inquiry insofar as opposite-sex couples in civil partnerships is concerned. But legitimate aim, and then at paragraph 161, we say in a difficult paragraph, Lord Justice Beatson says at paragraph 161, I do not consider that the discrimination in the status quo can be maintained for long. Pausing there, Lord Justice Beatson recognises this as discrimination requiring justification. There is no justification relied upon or identified by Lord Justice Beatson. What is relied upon only is the need to take remedial action. And we say, as you'll have seen from our printed case, and I'll have to advert to again in one moment, we say the need to take remedial action for the purposes of addressing otherwise unjustified discrimination cannot itself constitute either a legitimate aim or objective justification. It may go to the question of remedy, but it doesn't go to the question of justification, we say.
I mean, the government is saying our aim is perfectly reasonable. We've now got a sound, wider consultation in immediate prospect. And it sounds all quite attractive. But is it their aim, Ms. Monahan, or is it the aim of Section 3.1a of the Civil Partnership Act that we should be looking at? Two people are not eligible to register as civil partners of each other if they are not of the same sex. Is it not the aim of that provision that we focus on in asking whether there's a legitimate aim?
Well, the focus must be on the discrimination in issue, and the justification must be for the discrimination in issue. The discrimination in issue arises here because of the operation of Section 3.1 of the Civil Partnership Act and the Same-Sex Marriage Act. So it's the combination of those two provisions and the discrimination it creates that must be justified. Of course, as your Lordship knows, we're not here concerned with justifying Section 3 or justifying the Same-Sex Marriage Act. We're here concerned with justifying the discrimination. That is, that my clients are treated less favourably as opposed to a same-sex partnership. And it is that discrimination, not the broader statutory context, but it's that discrimination that requires justification. And the only purported justification relied upon is the need to take remedial action. So there is nothing other than that. And we say that may be a powerful consideration in relation to remedy. We don't say that for these purposes, but one can see how that could be a powerful consideration for remedy. If the matter were progressing through Parliament, see, for example, Nicklinson, one might take account of that. But it cannot constitute justification, we say, for the discrimination in issue. Remedy, not justification. Cannot constitute a legitimate aim. Cannot be in the hands of government, we say, to decide when it will remedy otherwise objectionable discrimination. That's a matter for the courts on the basis of any justification relied upon, and there's none here.
The discrimination is in the eligibility condition to enter into a civil partnership. And if we were to make a declaration of incompatibility, would it not be that statutory provision that we would be focusing on?
Yes.
Yeah.
But I beg your pardon.
And I was just going to ask you one other thing. In the benefits, the way legitimate aim is being discussed is very generalised. In the benefits cap case, there was some discussion of the relationship between legitimate aim and the substantive article of the convention that was engaged. And it was suggested that when the court is dealing with Article 14 in conjunction with Article 8, it's the Article 8 legitimate aims that tend to be looked at. If it were Article 14 in conjunction with A1P1, it's the A1P1 legitimate aims that are relevant, and so forth. In which case, it's a rather more narrow set of potential legitimate aims that are relevant. Now, I don't know that the Strasbourg Court itself has analysed the point, but that's an issue that might need to be thought about.
My Lord, I cannot bring to mind a Strasbourg decision where that's been thought about. I don't say that there hasn't been one, but certainly in our reading, I can't think of one. The court tends to take a rather flexible approach to the legitimacy of an aim. But if indeed one is looking at Article 8, then the point can be made even stronger that the aim relied upon by the respondent cannot possibly constitute a legitimate aim, doesn't fall within any of the
What you're saying is that they haven't identified something legitimate within the scope of Article 8 to which this discrimination is directed. That's what you're saying, isn't it?
Yes, my lady. And indeed, even if one took a broader approach, there isn't, we say, a legitimate aim that could be identified from the respondent's case. But certainly, if one is looking at Article 8, if that's the focus, then there can be nothing, we say, that could constitute or fall within the scope of the aims identified. It's not national security, public safety, economic well-being, prevention of disorder or crime, or protection of health or morals. And while I'm at the moral point, if I may, of course it's not said here by the government, as it has been in other cases, it's not said here by the government that this raises moral issues in some way. This is not about protecting the institution of marriage. So we're not in that territory. So the point can be made better, if I may say so, my lord, if your lordship's right and one analyses it through the prism of Article 8. But even if one doesn't analyse it through the prism of Article 8, we say it can only ever be a question of remedial action, not justification, where it doesn't go to the distinction in treatment in any way, in any substantive way.
I mean, the funny thing is that the government accepts this provision now is incompatible with human rights. And so, in a sense, what are we doing here, Ms. Monahan?
I don't know.
You're asking for a declaration of incompatibility. And looked at in the round, the government accepts that. We've got to do something about it. Trust us, we will.
Well, perhaps you'll have seen that the observations made by Lord Justice Beatson, that actually they haven't got much longer, they've got to get on with it. And you will see, I was about to take you to that, and I can see, I think, my Lord Reid picking it up, but paragraph 161 can't be maintained. Discrimination, do not consider it can be maintained for long. We are at this point in February 2017, so a year ago. And at paragraph 175, page 50, MS 213, Lord Justice Briggs, as he then was, I'm far from saying that every aspect of the internal reasoning of the state's weight and evaluate policy is beyond criticism, but we're not going to micromanage. Now, we're now in May 2018, and on Thursday, leaving aside the witness statement, which I trust you've had the opportunity to look at, but on Thursday, a command paper's published, providing what might be described as a roadmap for what's likely to happen now. I don't know whether your ladyships and your lordships have had the opportunity to look at it. It's not page numbered, I'm afraid, but it's paragraph numbered. So the bold headings tell you what's going to be done by way of information gathering. So trends in civil partnership and marriage among same-sex partners, and then over the page, assess demand for civil partnerships and marriage among opposite-sex couples. Pausing there, if I may, it's not clear why it's taken 5 years or 4 years, if one starts with the coming into force of the Act, to plan the sort of research that's identified here, and in particular that. Research into the motivations of same-sex couples who choose civil partnerships, and a review of what's happened in other countries. It's not clear why that would be particularly helpful, but perhaps somebody's thought about that. And then over the page, building a cost model, and then timing. By September 2019, so 6 years after the Same-Sex Marriage Act was enacted, we will have access to 4 full years of data on civil partnership formation following the introduction of marriage for same-sex couples. We will also have completed the activities set out above, giving us the information we need to make a well-informed assessment of potential demand by early 2020. Once these activities are complete, the government would be able to bring forward a set of proposals as part of a full public consultation. So 7 years after the enactment of the Same-Sex Marriage Act, 6 years after it coming into force, when the discrimination first arose, the government says it will put it out to consultation. Now, it cannot be, we say, it cannot be for the government to decide upon the date on which it will remedy any otherwise objectionable discrimination. And as my Lord Wilson's observed, it's not suggested that the distinction now is justified by itself, merely that time's required to remedy it. We say that cannot be right. It would make these rights ineffective and illusory if it were for the government to decide when any objectionable discrimination should be brought to an end.
Well, it can't be a basis on which to resist a declaration of incompatibility. I mean, on your case, the government has disavowed any justification for the unequal treatment. All it's saying is we need time to come up with the proper measure to remedy that. That, par excellence, cannot be a justification.
No. And that was the Bellinger point, of course. I mean, in Bellinger it was said, we're doing something, you don't need Section 4. And the court said, you know, the requirement to introduce remedial measures, or indeed the introduction of Section 4, doesn't turn unjustified discrimination into justified discrimination. That cannot be right, and it isn't right.
But you're asking for a declaration of incompatibility. Were we to grant one, that wouldn't be putting a date on this, would it, Ms. Monaghan?
No, but it would provide, well, first of all, it would provide a very clear steer so far as Parliament's concerned and the government's concerned, and so far as promoting legislation is concerned. I think pretty much all declarations of incompatibility have resulted in legislative change. I think prisoners
There's one
voting,
exception.
prisoners voting, is it? I think prisoners voting aside, they've all resulted in legislative change, which means that government and parliament show appropriate respect, if I may say so, for the court's judgments. And yes, it won't make an immediate difference. It may take some time, but one anticipates that change will occur. At least in any event, government and parliament will know that if they want to continue with the present arrangements, they are acting incompatibly with the convention.
Well, quite apart from that, there's a more fundamental point to be made here, is there not? The Human Rights Act enjoins courts to consider whether a particular measure is compatible with the convention rights of the individuals who challenge it. And arguably, at least, courts need to respond to that call by making a declaration of incompatibility where it is plainly evident. And it's not for courts to say, oh, well, I mean, there obviously is some limited discretion in courts as to whether to make a declaration of incompatibility, but it doesn't seem to me at this stage, at least, that it's appropriate for courts to disavow the obligation under the Human Rights Act to make a declaration where they have decided that there is an obvious incompatibility.
My lord, yes. And that was the Bellinger point, that it's the duty of the court to provide a remedy in circumstances where there is a violation of the convention rights. And in the context of discrimination, of course, I won't repeat this, but it's a very important obligation. It's absolutely quintessentially the court's function to take action where there is objectionable discrimination. But my lords, it won't surprise you to know that I adopt the observations that you've just identified.
I may change my mind, of course.
Just then...
Mr. Eady looks sceptical at that.
I'll just make a couple of observations. I'm not going to take you to all the cases on justification because you will know them inside out, but simply in determining whether or not, if we get past the stage of the legitimacy of the aim and we say it cannot be a legitimate aim for the continuance of discrimination that a remedy is going to be taken, that's a question of remedy, not objective justification. But if we get further than that, of course, your ladyships and your lordships will be very mindful of the strict scrutiny that applies in claims of sexual orientation, strict scrutiny. It was suggested at one point, as you will have seen from the judgment of Mrs. Justice Andrews, it was suggested by the respondent that less than strict scrutiny applied where the sexual orientation discrimination was against opposite-sex couples as opposed to same-sex couples. She rejected that argument, but just for your note, there is in fact a case on it, Ratzenbock, another Austrian case. Ratzenbock, which is volume 5, tab 33, MS 2330, in which at paragraphs 32 to 34, the European Court faced that issue head on and said strict scrutiny. So strict scrutiny, notwithstanding that they are not opposite-sex couples are not a historically disadvantaged group. There's no difference as between the test to be applied.
Well, that's a bit like sex discrimination, isn't it?
Yeah.
And the fact that historically the discrimination has tended to go all one way doesn't mean that it's just as deserving of strict scrutiny if the law discriminates against men.
That leaves the issue of the discretionary area of judgment. Rushing through it, I recognise, and conscious I hope that your ladyships and your lordships will stop me and ask questions if I've gone to it through it too quickly. But this idea of a discretionary area of judgment is relied upon. Plainly cannot rely on the margin of appreciation in the way it's understood at supranational level. Of course, it's for the national authorities to determine the answer to the particular question where a margin is granted by the European Court of Human Rights. And your ladyships and your lordships perhaps can be reminded of G, that's the joint adoption case. Don't need to take you to it, but volume 2, tab 9, MS 1169. That's the case, my lady, which I was going to take you to, but I don't need to trouble you with it, where you suggested that objections to marriage based on patriarchy were not good enough reasons now. But I hope I've persuaded you otherwise. Plainly that it's for the national court, or the national authorities rather, for the national authorities to determine a question where the European Court has determined that it's within the margin of appreciation. And again, discrimination, quintessentially a question for the court. Quintessentially a question for the court. Not something, not an area where there needs to be some deference or some concern about institutional competence. Quintessentially a matter for the courts. As for the discretionary area of judgment that otherwise is said to arise, again, this is about institutional competence. There is nothing in Kebeline, nothing in SG, nothing in Nicholson, and nothing in Countryside Alliance that upsets the general principle that, in particular, in discrimination claims, see Keidan, it's the responsibility of the court to determine whether or not there's objective justification. It's the responsibility. And all of those claims were very different, it goes without saying. SG, the benefit cap case, a lower threshold for proportionality. Countryside Alliance, recent consideration by Parliament, not here. Nicholson, profound moral and ethical judgments to be made, although even there, the majority of the court concluded that determining the question was within the court's function, that is, it had institutional competence, though there was legislation in place, as you know. As to the point in time, at which differences in treatment become unjustified, so far as the European Court's concerned, I'll just take this point a little slower. It's said at various points by the respondent that the European Court recognises that time may be required to put right something that's wrong. There are two, we say, discrete issues that arise in that context. One is, when does the discrimination become unlawful? And many of the cases, so that's one, many of the cases that concern timing are concerned with margin of appreciation or justification. In other words, the European Court of Human Rights is saying at this point, it is not unlawful. It falls within, or it doesn't contravene the convention rights. It falls within the margin. It's for the state authorities to decide. Or time hasn't sufficiently passed, there hasn't been the social evolution that they talk about regularly to make the decision in issue or the complaint in issue unjustified, contravention of the convention rights. We're not in that territory here because it's not said this distinction in treatment is justified. There is still a role for differences between same-sex couples and opposite-sex. We all sigh relief that it wasn't us that this happens.
Yes.
It wasn't us.
So the first point I was making is the timing issues, the first class of case, those where there is not any convention violation at all, because the time hasn't arrived, where the margin is narrowed, or where life has moved on sufficiently to mean that the justification is no longer present, for want of a better expression. But we're not in that territory here. The government doesn't say here, this is justified discrimination because things are still different between same-sex couples and opposite-sex couples. We're not there. The government recognises here that this has to change because the distinction cannot remain because there is no continuing justification for it. The second class of case in relation to timing concerns the need to take practical steps, to introduce legislation, to take the necessary steps to get rid of the discrimination in issue. And I perhaps can just take you to one case on that, if I may. Just see if I need to take you to two before I say that. I may just take you to Bellinger as well, but if I can just take you to Hooper first, please. Volume 2, tab 14, MS 1433, tab 14, volume 2. This was the, I know this case will be very familiar to you, but concerned the widowers' benefits, the three classes of benefits, widow's payment, widow's mother allowance and widow's pension, ultimately found that the distinction, that is between widows and widowers, in relation to widow's payment and widow's mother's allowance was unjustified, but justified in respect of widow's pension because of the position of women generally in terms of the resources available to them and so on. If I can ask you please to turn up paragraphs 51 to 53, internal numbering, sorry, I beg your pardon, that's my mistake, sorry. Internal numbering, let me just stop that again. So, volume 2, tab 14, and that's MS 1433, and paragraph 41, forgive me, paragraph 41, page 1694, internal, MS 1446.
41, not 51.
It's 41, I beg your pardon. So it's MS 1446, paragraph 41. Paragraph 41, first of all. This is Lord Hoffman, who deals with this point. Paragraph 41, no objective justification is claimed for the payment of widows' payment and widows' maintenance allowance. Mother's allowance, thank you, at the relevant time. The Secretary of State does submit, so no justification claimed, entirely on point here. We are in that situation. No objective justification claimed for the discrimination. Secretary of State does submit, in an argument based on the unreported decision of the European Court in Walden, Liechtenstein, that there was nevertheless no breach of the Convention rights because Parliament had to be allowed a reasonable time to legislate to put the matter right. I'll come back to this point, and I'll just take you to what Lord Hoffman says about that now, please. Paragraphs 60 to 63 at MS 1450 deals with Walden, which is, if I may say so with respect, a difficult case, describes the situation in Walden where there was, the Constitutional Court had found objectionable discrimination. And then at 61, applicant complained that until the new law came into force, his convention rights had been violated. The Strasbourg court agreed with the domestic courts that the previous law had violated the applicant's rights, but held that in the events which had happened, the refusal to quash the law was equivalent to suspending it, and the temporary preservation of the old law served the legitimate aim of maintaining legal certainty. Paragraph 62, Lord
And the period of just over 6 months was proportionate.
I should have added that, yes, not 7 years. But I must confess to finding this a puzzling decision, which may be explicable by reference to the way it was argued. The submissions concentrated on the question whether the state should have set the provisions aside. I can quite understand that if one has a form of discrimination which was historically justified, but with changes in society has gradually lost its justification, a period of consultation, drafting and debate must be included in the time which the legislature may reasonably consider appropriate for making the change. Up to the point at which that time is exceeded, there's no violation of the right. But there's no suggestion in the report of Walden that discrimination between married couples was ever justified, and I find it hard to see where there was no violation of the convention rights as long as the law remained in place. That is precisely the position here. Once there was a distinction in treatment introduced, as between same-sex partners and opposite-sex partners, it's never been contended that that was at any point justified, and there cannot be any justification arising from the time needed to put right that discrimination.
Now, Ms. Monaghan, we have to note that Lord Hoffman is there saying that until a reasonable time for sorting it out has expired, there is no violation of a convention right. He doesn't appear to be putting it in terms of, well, the remedy may have to take account of the fact they need time. No violation.
But
Do you agree with that?
My Lord, the difference in this case is that the Lord Hoffman makes clear that he is concerned there with a particular class of discrimination claims, rather like that class I was just alluding to a moment ago. That is where there has been historically justified discrimination, typically, for example, in the case of differentials in pension ages as between women and men. There has been justified discrimination, and times have changed, and there needs to be a period to put it right. We say, in this case, there has never been justification for the discrimination complained of here. There's been justification for the Civil Partnership Act, there's been justification for opposite-sex marriage, but at the point the discrimination arose here, we say there's never been justification as compared to the class of cases we say that Lord Hoffman was focusing on there. So we say there's a distinction where there's never been justification. The applicant, or my clients, are entitled to a declaration that there has been a violation of their rights, since there has never been justification for it at all.
Well, there was justification up until 2013-14.
There was no discrimination between 2013, before 2013.
So there was no discrimination.
The
So historically, everything was okay.
Yes.
At first.
Yes. Contrary to the sort of cases, or to the class of cases that Lord Hoffman is concerned with here. Lord Hoffman is concerned with a case where the discrimination, we don't have discrimination until 2013, where the discrimination has historically been justified, but that justification has diminished over time. There needs to be a period to put that right, and until that period has expired, there's no violation. Here, we are in a different class of case, because the discrimination, when it arose in 2013, none before, when it arose in 2013, was never justified. That's the way we put the case, my Lord.
And one also mustn't lose track of the fact that in Walden it was a period of just over 6 months.
Yes.
Under a scheme where the Constitutional Court could suspend up to 6 months the operation of its decision.
Yes, thank you.
Well,
Yes.
obviously, it's a much longer period in the present case.
Yes, precisely, and we certainly rely on that. But I'll just pick up my notes and make sure I haven't got anything else to say. Yes, so the two classes of case, one where it continues to be justified because time hasn't sufficiently moved on, one where it was justified but justification has diminished. We don't fall into either of those classes. We're entitled to our declaration immediately. But we also do pick up the point that even if the aim identified by the respondent could be characterised as legitimate, and that there is some role for the granting of time to remedy always objectionable discrimination, that is, discrimination that has never been justified, even if the law permits some period of time, it is wholly disproportionate in this case. I mean, we are 7 years before consultation, we're told by the government. It cannot be for the government to tell the court that the court ought not to interfere until it has decided that it is ready to remedy discrimination which has always been objectionable.
A point that perhaps worth emphasising is that Walden and related cases, as Lord Hoffman mentions in paragraph 61, are justified by the need to maintain legal certainty. So a classic example would be Marx in Belgium,
Yeah.
where it's established that discriminating against illegitimate children in relation to succession rights is and always has been unjustifiable discrimination. But the court makes its decision prospective because it doesn't want to upset existing settlements that people have made. If you ask yourself in the present case, what is the interest of legal certainty that's being served? It's not so clear.
Well, it's not so clear. I mean, it's not apparent at all, my lord.
I think you would submit that there is no legal certainty. The only certainty is that this is discrimination.
Yes, that is the only certainty. And it doesn't serve any particular interest. And no interest has been identified. Certainly not legal certainty, but no interest at all has been identified. Just check. Is there anything else I need to say, actually? I think subject to any questions from the court, I may have said enough, subject, as I've indicated, to any observations by the court, but perhaps if we do get through things pretty quickly, I might be afforded a reply.
Well, yes, that is your right. Bearing in mind the way that between you have allocated the time, you do have a right to a reply. And so...
I hope I haven't done an injustice to my client's case, but no doubt you will ask any questions if there are any remaining.
Well, it's our business to make sure that no injustice is done to either side's case. Thank you. Thank you very much. Miss Hannett, do you wish to say anything?
My ladies, my lords, I'm going to start, if I may, with the key stages of evolution, for obvious reasons, I hope. And I start with the period prior to the CPA 2004. There was, in the period leading up to that piece of legislation, no legal recognition of same-sex relationships. Society and the law simply had the institution and the legal rights and obligations flowing from marriage, and that was only available, both of those things were only available for opposite sex couples. neither that institution of marriage nor legal rights and obligations flowing from it were available up to that point to same-sex couples. So there was, up till that point, a significant difference of treatment between opposite-sex couples and same-sex couples, both as to legal rights and obligations and as to the availability of the only legal recognition afforded to couples. There was no alternative to marriage for anyone, whether the same sex or opposite sex, up till that point. And so up till that point, opposite sex couples who objected to marriage on whatever grounds did not have any alternative legal status. Marriage was it. And we know, despite the fact that those differences of treatment were based on sexual orientation, in effect, we know that for some years after 2005, when the CPA came into force, under the ECHR scheme, even the position of same-sex couples in that situation was defensible. And we know that from the Schalk and Austria case, Bundle 5, if you would, tab 36, MS 2386. You see the essential facts for present purposes from the first paragraph H1 on page 2386. The applicants were a same-sex couple living in Vienna. In September 2002, they requested the Office for Matters of Personal Status to start the process of enabling them to contract in marriage. The request was refused on the basis that the domestic law defined marriage as being between two persons of opposite sex. But there were a range of complaints that were made in this case. As one sees, if you go forward to the relevant part of the judgment, which is essentially between 96, paras 96 on page 2405 and 110, where no violation of Article 14 read with Article 8 is found. For present purposes, and for the purposes of this point, in other words, that position for some years after the CPA is introduced remained acceptable despite its severity if one judges it in modern terms, even that position was defensible. One sees para 101 to the end of 106. If I can invite you just to cast an eye down there. 101 finds no violation of Article 14, even though the Austrian system did not permit same-sex couples to marry. So they reject that because they find no right inherent within Article 12, and the same result follows in relation to Article 14. So 101 is no marriage. That was the first complaint. No violation. The second complaint was that it had taken a long time until January the 1st, 2010, as one sees from 102, for the Austrian system to move even to the place where some form of legal recognition is afforded to same-sex couples. So that is 5 years after our CPA 2004 comes into force, and yet they conclude that even in relation to same-sex couples, there is no violation on that basis. If you read 102 to the end of 106, you see that finding.
Can't be reproached for not having introduced the Registered Partnership Act any earlier.
My lady, that's exactly it. And they do so, as you see, on the basis of the considerations in particular at paragraph 105, namely that this whole area involves an evolution of society's values across the Council of Europe, with various rights being afforded in various different ways in various different of the states. And there is no established consensus. And in that situation, as they put it, in 105, final sentence, the area in question must therefore still be regarded as one of evolving rights with no established consensus, where states must also enjoy a margin of appreciation in the timing of the introduction of legislative changes. So that was the position for some years after we got ahead of the curve, if I can put it that way. That was the position certainly up to the introduction of our CPA. If you couldn't be criticised under Article 14 grounds, even in relation to same-sex couples for years afterwards, it follows for the period before that Act, we were also not in violation in having nothing, no form of legal recognition whatever, even for same-sex couples. And we respectfully submit that, again, still in the period prior to the CPA 2004, the position of opposite-sex couples who objected to marriage, up till that point, was a fortiori. They had no legal status available to them because of their objection. They had no legal rights and obligations that were consequent upon the institution of marriage open to them for the same reason. And there is no suggestion, indeed it's accepted by these appellants, that if the alternative of civil partnerships had never existed, there would be no obligation to invent one. You have the position in Strasbourg, therefore, encapsulated in 2011 in the Schalke and Austria case, so far as that is concerned.
Well, you also have, it was a 4-3 decision.
It was a 4-3 decision.
With a very powerful joint dissenting opinion.
My lady, quite so.
Certain prominent members of the court.
Maybe so.
I merely observe.
But it's a 4-3 decision in my favour.
Chamber 4-3 decision. It is in your favour.
Right. You also have two domestic authorities to exactly the same effect, or to substantially the same effect, where the issue arose as to whether the CPA itself should have been enacted and civil partnerships available earlier under our own domestic law, and you have the same rejection of that being a violation of Article 14 in the context of the United Kingdom, with the same essential reasoning based on evolution of rights alongside evolution of social values and margin. The first one is in Volume 4, tab 21, and it's a case called Courten, C-O-U-R-T-E-N, and the United Kingdom, 1953 in the electronic, tab 21 in bundle 4. This was a unanimous decision, again of the Chamber, and again comprising, no doubt, powerful judges. It was an admissibility decision. And you see the essential facts from page 1954, if you just look at the second full paragraph on that page. And you will see that, in this case, a same-sex couple were asking for the same extra statutory tax concessions from inheritance tax that were available to opposite-sex spouses who could access the institution and the legal rights and obligations of marriage. You see the nature of the complaint, Article 14 read with A1P1 on page 1955 under the law. And you see the essence of the reasoning in the penultimate paragraph of the admissibility decision on page 1958. Again, I'm very happy to read it out, but it may be quicker to read it to yourselves. So the paragraph, the first full paragraph on the page, the applicant has pointed out. And you will see in particular that precisely the same form of words is used as had been used in the, as was used some years later in the Schalke decision. I get my sequencing right.
Yes.
But you see it halfway down the paragraph. However, in the area of evolving social rights, where there is no established consensus, states must also enjoy a margin of appreciation in the timing of the introduction of legislative changes. So the same reasoning but this time in a specific UK context 5 years earlier, where exactly the same basic complaint is made. You haven't moved your law quick enough to afford basic legal recognition to those who are in same-sex relationships. And domestically, one has a similar set of issues arising in the M for mummy case, bundle 2, tab 11, MS 1326. This was a decision of the House of Lords by a majority of 4-1 with Lady Hale dissenting.
But she did well in Strasbourg.
She did well in Strasbourg. I take that as a given.
Doesn't invariably happen.
The reason I want this case is principally for the speech of Lord Mance at paragraph 153. MS 1326.
Yes.
And my ladies, my lords, you will see that to similar effect, can I just invite you to sideline and cast an eye briefly down Lord Walker at paragraph 91, going backwards. And Lord Bingham at paragraph 6. So Lord Walker 91 on page 1304. And Lord Bingham at paragraph 6. Page 1281. It is, of course, to be added that it's a necessary element of social and legal evolution that at some point, it implies that at some point one may well reach the position defined in the Strasbourg case law, especially by established consensus as to the position among member states, when a state falls outside or moves, as it were, outside the margin. And in summary, you then have to provide the now widely provided recognition or status. And that was the position, as we will see in due course, in relation to the non-provision of any form of legal recognition and protection to same-sex unions. And that position was ultimately reached, as we will see in due course, in around 2014-15 in the cases of Oliari in Italy and Valiantos in Greece, which I'll come back to. But so that's the position up to the CPA 2004 coming into effect. The CPA then is the second stage of the evolution. The CPA then comes into force on the 5th of December 2005. And its purpose, its fundamental purpose, was to remedy the difference of treatment of same-sex couples who had access to no legal status. And by that I mean no institution and no consequent legal rights and obligations. And Parliament made the decision that that was no longer in accord with society's values, and then had a series of decisions to make. That is, Parliament had a series of decisions to make. Should there be rights and obligations on the same or a different basis to those who were married for same-sex couples? Should Parliament open up the institution of marriage or create a new civil status? And if a new civil status, to whom should that civil status be open. Same-sex couples and opposite-sex couples or not. And the decision that Parliament made in that legislation was to accord the same, not different, rights and responsibilities as those flowing from marriage to same-sex couples. And that basic change and position was the one described by my lady, Lady Hale, in M, paragraph 99, and you saw it earlier on referred to by Lord Mance as being much to the credit of the United Kingdom. That was step one, if you will, in the extension of rights to same-sex couples. But it did not extend, Parliament did not extend the availability of marriage itself at that time. So marriage remained only available to opposite-sex couples. So the distinction or the difference in our law remained simply based on sexual orientation. Parliament did not open up the new status of civil partnerships to opposite-sex couples. So that position remained as it was before. No civil partnerships available to opposite-sex couples. So also distinctions being drawn and maintained on the grounds of orientation. Its limited purpose was thus only, and I don't underestimate the extent and significance of the change by using that word, but its limited purpose thus only extended to same-sex couples. So at this point, one now has equivalence in terms of legal rights and obligations when comparing same and opposite-sex couples, but single-sex couples still can't marry, and the position of opposite-sex couples who object to marriage, or indeed same-sex couples who object to marriage, there is still no alternative legal institution to the institution of marriage. But it's accepted by these appellants that at that point, and despite that fact, the position then was compatible. Our law was compatible. And that's the position as it remained for the next 8 or 9 years. And so there are perhaps 3 points to note on the case law relevant to this state of evolution. First, and as I've already noted, this introduction of civil partnerships with that limited purpose therefore did not alter the position that the institution and legal rights and obligations available to opposite-sex couples remained one of marriage.
Did anyone bring a case claiming that it was discrimination against opposite-sex couples to deny them civil partnership?
Well, you've got equivalent. I'm going to take you to that in a moment because it's virtually the Ratzenbach decision, that.
I was thinking in the UK.
I don't know is the answer to that, but may I check? And
Well, it's just interesting,
yeah.
bearing in mind what you've just said.
Yeah. Would you just give me a moment? We'll find out. It's being whispered to me that it was declared inadmissible, but we'll find out. But the new status is designed to create equivalent rights now available only to same-sex couples. I was going to take you to Ratzenbach. I mentioned Ratzenbach. If you go to volume 5 again, if you would, tab 33. This is in October 2000, MS 2330. This is a case against Austria again, and it's a decision of the Strasbourg Court, the 5th section of the 26th of October 2017. And this was a direct challenge by opposite-sex couples to their exclusion from the Austrian equivalent of civil partnership. So in Austria, we have, as it were, an exact mirror of our law as it existed at this stage of the evolution. In other words, marriage for opposite-sex couples, civil partnerships for same-sex couples, and nothing else. and the opposite-sex couples challenged that. As you see from paragraph 7 on 2332, in this case, the opposite-sex couple applied to be registered under the Registered Partnership Act, in other words, the Civil Partnership Act. And that was dismissed, as you see from para 7, because they didn't meet the legal requirements, as registered partnership was exclusively reserved for same-sex couples. So I think we'll see if there's a UK challenge, but this is that
Yes,
that challenge.
This is
as it
that
were.
case, yes.
I think it's that case in the context of Austria. And you see the court's reasoning starting at 31 and running through to 42. So MS 2339 for the next few pages. And they set out, this is all interesting reading, not least because it casts, as it were, high the general principle about differences based solely on considerations of sexual orientation, as one sees from para 32 in the Statement of General Principles. And you see the nature of the issue as the court identifies it in para 33, particularly that first sentence. They place reliance upon the Schalk case, which we've seen in Austria, which is para 35. They then analyse and place reliance upon Valiantos at 36 and Oliari at 37, and I'll come back to both of those because they're a bit later in time, as it were, so far as our evolution is concerned. And then they apply those general principles to the present case at 38 and following.
And 42 is the conclusion.
It is. It's 41 and 42, my lady, you're right.
They're not in the same situation because they can marry, whereas same-sex couples can't marry.
Exactly so.
They've both got an institution available to them with roughly the same, well, in fact, exactly by then, the same legal consequences.
So this is the exact mirror of our law at that stage of evolution. No violation. Acceptable even though, therefore, opposite sex couples are excluded from the civil partnership, and that the ground of distinction is sexual orientation. And that conclusion is reached even though sexual orientation or differences based solely on considerations of sexual orientation are unacceptable, their words, in para 32. So that's the first point I would make on the state of evolution at this stage. Secondly, the fact that same-sex couples could not marry, whilst opposite-sex couples could do so when the law was in this state, was not a breach of either Article 12 or Article 8/14. See Schalke and the analysis of Schalke in Ratzenbock at 35. Thirdly, nor would it have been a violation if the system had created differences between, in other words, the legal obligations and rights flowing from the institutions, nor would it have been a violation if the law in Austria or our law had created differences in that respect between the statuses of marriage on the one hand and civil partnership on the other. And again, that is The Schalk decision confirmed again in Ratzenbach at para 35. And the thing that links all of those three together and that links the reasoning of the court together in this line of cases, this run of cases, the underpinning for the court's conclusions is essentially the same. You've got a situation in which there are evolving rights with no consensus as to either the availability of institutions or the availability of particular rights and obligations across Europe, different and difficult social judgments, different stages of evolution, and the margin applicable accordingly. So that's the second stage of our evolution. The third stage involved the introduction of the Marriage Same-Sex Couples Act 2013. It came into effect from the 13th of March 2014, and it represented, if you will, step 2 in the extension of rights under our law to same-sex couples. And again, the United Kingdom in that respect was in the vanguard of affording and extending those rights compared to the rest of the states in the Council of Europe, or many of them. But again, in relation to the introduction of that change, there was no change to the Civil Partnership Act's coverage, and it was a change that still only related to same-sex couples. So that's stage 3. I come back to the developments because there's case law in Strasbourg after the Marriage Same-Sex Couples Act 2013. We've seen some of the limits in Ratzenbach, but just to trace through the development in Strasbourg, so you see that where that case law in Strasbourg ended up. If you go first, if you would, to Oliari in Italy, Bundle 4.
But the reasoning in Ratzenbach wouldn't apply once same-sex couples had access to marriage. The whole point in Ratzenbach was that they didn't, and that's why they weren't comparable to opposite-sex couples.
My lord, that's true. They analysed it on the basis of comparability. They did. But that's why I referred to it at this stage of the evolution, because at that stage we didn't have the complication, as it were, created by the creation of the difference of treatment under the Marriage Act in our law 2013, which is obviously the subject of our issue here, which I'm going to address. But my lord is right. I think it was the point my lady drew attention to. They analysed it on the basis of comparability. But it's all part of the theme, the reliance upon Schalke, the question of how far other states have developed and so on. So Bundle 4, just to show you the limits of the, or the way in which the law then developed. Bundle 4, tab 29.
Is that Oliari?
That's Oliari. 2161 is the first page. And this is July 2015, although it took a while to get into the law reports. And you see the basic context from H1 on page 2161. And the reasoning of the court in a relevant part starts under the court's assessment at para 1592205. They analysed the question here under Article 8, and they address well-known distinctions between positive and negative obligations that might be imposed under Article 8. And you see what they say at 162 about margin, para 162 at the bottom of page 2205. And you see the essential scope of the issue being analysed at 163 and 164, where they explain the Schalk case. And so the position here in relation to Italy is that same-sex couples can't access marriage, and nor is there a civil partnership alternative. And so that's why the question arises, at what point does the margin get exhausted? At what point in time does the evolution take a state's recognitions outside the acceptable margin? And you see that in the court's judgment at 172, the particular difficulties that arose for same-sex couples under Italian law. And the court's reasoning is perhaps, to pick up the essential reasoning that leads them to violation as a conclusion, pick it up at 177. That's why I made the distinction between differences flowing from the status of, for example, CPs versus marriages. So you've got a set of issues around that. If you're going to afford marriage and civil partnerships, are they to have the same legal rights and obligations attached to them? There may be a margin in relation to that issue, say the court, but the issue that confronts them here is whether or not even the basic legal recognition is properly to be afforded to same-sex couples. They then attach considerable importance to the indications across the Council of Europe at 178 and the indications of social movement, if I can put it that way, social evolution, even within the context of the Italian system, as one sees from 180, repeated calls for some form of recognition to be afforded. So they're out of kilter with the consensus in Europe. They're out of kilter with the repeated calls for some form of basic legal recognition for same-sex couples from the Italian court system and indeed from surveys, see 182. And their conclusion at 185 is that they've overstepped the margin. Or put another
And
way.
we see from the schedule that's been produced last week that a year later, Italy introduced a civil union for same-sex couples.
Exactly so. But my lord, this is about, the margin is exhausted in, as it were, 2015, or whenever this case was ultimately promulgated, but the margin is exhausted in relation to same-sex couples, and it's exhausted in relation to the basic legal recognition, some form of basic legal recognition, whilst emphasising at the same time that the margin will continue to exist in relation to lesser issues, such as whether or not there should be a distinction between the rights and obligations flowing from marriage as compared to civil partnerships. But so the margin is exhausted, as it were, in relation to same-sex couples in 2015. Then Valiantos and Greece, if you put that bundle away and go to bundle 5, tab 37, MS 2413, and in a nutshell, what Greece had done was to have the availability of marriage for opposite-sex couples. They then introduced civil partnerships for opposite-sex couples, but not for same-sex couples. So same-sex couples had neither marriage nor civil partnerships. And the defence mounted by the Greek government was recorded at paragraph 80 on page 2438.
Well, they said that same-sex couples could contract into the relevant economic benefits, and the Strasbourg court said that wasn't good enough.
Not good enough. Three basic strands of reasoning. Again, I'm not going to go through it all now, because you see the basic nature of the arguments being advanced. In fact, there were two things being said by the Greek government, as you see from 80. One was the point my Lord has just put to me, and the second one was that it strengthened the institution of marriage to have civil partnerships for opposite-sex couples, to which it might be thought, and the answer ultimately given by the court is, so what? That's not a justification, as it were, for not having any basic form of recognition for same-sex couples. And so that's the argument effectively mounted by the Greek government, rejected for all the reasons that the court sets out in the following paragraphs. And there are, as you will see when you cast your eye through those paragraphs, three essential strands of reasoning which led the court to conclude that there was a violation of Article 14 read with Article 8, and this is a decision of November 2013. And the three strands of reasoning are, firstly, the basic position remained, even if a state does not extend marriage, civil partnerships for same-sex couples would be and is the required way of recognising a relationship in core need of protection. In other words, a same-sex couple relationship. See 81 and then 90 in terms of the paragraphs for that. So here's a relationship, same-sex couple in need of legal protection, and you have none, apart from the contracting, which doesn't do it. Secondly, the other aims advanced by the Greek government, protecting children born outside wedlock by providing the civil partnership regime, and the essence of the court's reasoning in relation to that is all jolly good, but beside the point. You can achieve all of those aims in a nutshell whilst still affording the requisite protection at a base level to same-sex couples. See paragraph 89. And thirdly, consensus. See para 91. So what are the conclusions in relation to the European Court of Human Rights case law that we respectfully invite the court to draw? We say there are 6 points that flow from that case law, that development, that evolution in the case law. But firstly, there is evolving recognition of the rights of those who are in same-sex relations. And the position has now been reached, and it took a number of years to reach it, but the position has now been reached in which there is a requirement in Article 8/14 or Article 8 for some basic recognition by states of that status. Secondly, that position has been reached centrally on the basis of the fact that those are relationships, same-sex relationships, that are to be recognised under the ECHR system as in need of legal protection, and of the fact that they therefore have, as it was put in at least one of the cases, I think it's para 185 of Oliari in Italy, those who are same-sex couples have, as it was put there very unusually for the court to use this sort of adjective, monumental interests in some form of legal recognition.
Monumentous.
Monumentous, I'm sorry.
Or even momentous.
Or even momentous.
Momentous,
One of them.
yes. Quite.
Let's see.
Whilst we've stopped on that,
Yeah.
that very paragraph, I don't know if you've got it open, have you? If not, we'll come back to it. Come back to it. It'll wait.
I was going to check the adjective.
It was momentous.
It was momentous.
Valianatos was a Grand Chamber decision
It was.
in 2013.
It was.
You've got to have something.
Yeah. It was.
But that was on the basis of Article 8 in conjunction with Article 14. Oliari, it was Article 8 that didn't bother with the discrimination argument. It's interesting. That's an evolution.
I'm not sure there's subsequent case law, which, as it were, it explains the significance of that evolution. But my lady is right. It was Grand Chamber. I should have pointed that out. I think I'm right in saying it's probably the only Grand Chamber authority in this sphere. I can't think of another one. Most of the other ones are Chamber.
Well, apart from Bern.
Apart from that, which is quoted in one of them. My lady, I don't know whether you wanted, I've got the paragraph open, if that's...
No, it was simply that the way it was put in the introduction of that paragraph, before they start considering the balance of, however we describe it, interests, is that it's speaking of the absence of a prevailing community interest put forward by the Italian government. And I was interested in a couple of sentences to know what your prevailing community interest was here.
Well, my prevailing community interest is going to be, ultimately be enabling Parliament to make the best informed decision it can about how to deal with the difference created by the 2014 Act. But I'll come to define that more closely when I come to deal with legitimate aim, if I may. But the community, you see why they put the point in that way there, and they have to do the balance under Article 14 as part of the analysis anyway, and that's the significance, as it were, of 178 to 182, with the consensus moving against them, the Italian courts moving against them, the surveys in Italy moving against them, and in effect, therefore, a movement of societal values without an equivalent movement of law.
So it's slightly curious. We're concerned about Section 31A of the 2013 Act, which says you can't enter into civil partnership if you're of different sexes, and your justification isn't actually directed towards the provision, but rather towards a failure to address the provision more by the state.
My lord, it is, and I'm going to have to make that good.
Yeah.
We don't, as you've seen, the court has already, I well understand from this morning's exchanges, picked up the point. We don't, as it were, seek to say there is a long-term justification for the difference of treatment that was created by the 2014 Act.
No, you're not really saying that the difference in treatment in Section 31A is compatible with Article 14.
It was compatible with Article 14 and 8. That's why I took you through the stages of social evolution.
Yes.
And has moved out of kilter when we introduced the new ability of same-sex couples to enter the institution of marriage. And the question that arises at the moment when they enact that act is, what now do we do about civil partnerships? And I will make the submission in due course that the choice that then confronts Parliament is not an uncomplicated one.
Yeah. But it is incompatible at the moment that the 2013 Act comes into force.
I don't accept that way of putting it. I say that that Act created the difference of treatment which now has to be justified, and my justification does not depend upon a defence, as it were, or an intrinsic defence of that difference. It does depend upon allowing Parliament a proper time to work out what the options should be. But can I develop that when I come to it? But that's my... That's the answer that's going to persuade my lord to change his mind.
Oh, well, You've done that frequently, Mr. Easton.
Almost never, I think.
Well, that's another historical inquiry we won't go into now.
It is another historical inquiry altogether.
Were you on point 2? Or
I was on point 2.
Yes,
Yeah, I
I
was.
thought
I was
so.
going to move on to point 3, if I may.
Please.
There are only 6 of them, so if I can try the court's patience to that extent. Thirdly, it remains, this is a European Court of Human Rights approach, even in relation to same-sex couples, it remains the position under ECHR law that only some form of legal recognition is to be accorded to same-sex couples. And I put it that way because it's evident from the case law I've taken you to that even in relation to that group, same-sex couples, states still have a margin based on lack of consensus and still evolving societal values. So there is still scope for different state answers and different, and this would be compatible, for different state answers to be to apply in relation to marriage. Should same-sex couples be, should the institution of marriage be open to same-sex couples? Still margin, still no settled position in the Council of Europe, and there is still margin in relation to the precise form and nature of the legal protection that is to be provided. So you can have, as it were, subject no doubt to an outer limit, one can have a lesser form of protection under civil partnerships if that's the way you choose to accord that basic recognition to same-sex couples in a system where marriage has not been opened up. You can have a lesser form of protection. So there's still social issues, social evolution in relation to those matters, but the core, the place where the margin stops, is basic legal recognition for same-sex couples. That's the third proposition. Fourthly, so far as opposite-sex couples are concerned, marriage has always been available. So there is, in our law as in other systems of law, a formal legal ability to have the status of that relationship recognised, and that is sufficient protection under the ECHR system for the core rights of opposite-sex couples, the mere availability of marriage. Fifthly, they, that is opposite-sex couples, have no ECHR right to have an alternative civil status created for them in circumstances where marriage is available, even if they object for whatever reason to marriage. Nor do opposite-sex couples have a right under the ECHR system to participate in alternative civil mechanisms for protection. And sixthly and finally, running through the jurisprudence we submit is a recognition of and sensitivity by the European Court to the fact that these are cutting-edge social issues which throw up judgments and issues of real difficulty. The development is clear in its recognition now of the core and momentous interests in a basic recognition by law of the rights of same-sex couples. But outside that area, outside that basic and core protection, the Strasbourg Court has been very and properly cautious. It's afforded a broad margin as to both how far and, see all the references to the margin extending to the timing of change, how fast to move. And within that area, in other words, within the area where that margin still operates, which is essentially every bit of the area apart from basic recognition of core legal rights for same-sex couples and the availability of the institution of marriage. If you're outside that, you're in margin territory. And within that area, it is appropriate is the theme of the case law, for states, particularly those states it might be thought who are in or towards the vanguard of the development of these sorts of social rights, to proceed with real care and real consideration. And there's nothing to suggest that the Strasbourg Court would not respect that approach. On the contrary. Just to finish, if I may, in the last few minutes before the short adjournment of this position, and then I'm going to go on to the extent and nature of impact on people in the position of these appellants, and to move, as it were, from the themes that come out of that evolution and that development of the social and legal history and the Strasbourg case law sitting alongside it. I've looked at the ECHR and the European Court's themes, as it were. So far as the UK and our system is concerned, I do make the submission that the United Kingdom is and remains in the vanguard. So far as same-sex couples, the developments in our law were not done all in one go. Step 1 and Step 2 occurred. There were 2 legislative steps to cover, first of all, the legal rights and obligations that flowed from the relationship in question. That was done under the Civil Partnership Act. And secondly, and then, to open up the institution, the socially valued institution of marriage to same-sex couples. And that 2-step legislative process, in advance of developments in the Council of Europe, in advance of the requirements of compatibility, has created and did create legacy issues as to the status designed as the alternative to marriage with its limited purpose when first set up, which was to accord the same legal rights and obligations to same-sex partners. But that's created when you extend the marriage institution to same-sex partners, that's created a set of legacy issues. But those, so far as same-sex couples are concerned, have been, I respectfully submit, fundamentally progressive steps. And the differences of treatment have shrunk both in number, and it may fairly be said in relation to the impact on individuals as our system has developed, and that's a thoroughly good and progressive thing. So same-sex relationships are now afforded both equivalent legal protection and access to society's long-standing relationship institution, that of marriage. There is legal rights and obligations equivalence, and those legal rights and obligations apply in just the same way to the same and opposite sex couples. And the institution of marriage, with its special status, also is open on the same basis to same and opposite sex couples. So all of those have been positive and progressive steps in our law, and the position, so far as opposite sex couples are concerned, just focus on them directly, has not changed in terms of the basic availability of institutions and legal rights and obligations to them in our system of law. They have never had access to any other recognised status apart from marriage. But as we will see, and I'll come back to it after the short adjournment, the forms of marriage have changed to accommodate the change in societal values, including increasing secularisation. Civil marriages are now possible with no religious content, where in practice they are, in terms of ceremony, as it were, virtually identical to civil partnerships. You can have vows or promises to suit your own cultural beliefs if you choose to enter into the institution of marriage. And marriage is now a relationship which, as a matter of law, is both inclusive and equal in a way it may not have been in the past. And what is left over, therefore, so their position has never changed. It's always been the same. And if you object to marriage on conscientious grounds, that has always been the same. If you're an opposite-sex couple. What is left over is in large part as a legacy of the historical development and evolution of the rights afforded to same-sex couples, and the set of issues that now confront this court, the government and Parliament is how to deal with the remaining and historically consequential position. And the differences of treatment in this area are now down to one, in effect. Civil partnerships were created in order to equalise rights and obligations for the benefit of same-sex couples, and they remain in place. And there is therefore not a rights and obligations difference, nor a difference in accessing society's long-standing institution of marriage, but there is currently a difference in that opposite-sex couples are not able to access the historically recently created civil partnership institution. My lady, that may be a convenient moment to
Looks
break of that.
virtually ideal. We'll adjourn now and look forward to hearing from you further at 2 o'clock.